Okay, so today we're going to look at problems and difficulties faced by individuals in using the legal system. So for this area of the study design, you need to know problems and difficulties that individuals face in using the legal system. You need to know at least 2 problems. You also need to know recent changes that seek to address those problems, that seek to improve the effectiveness of the legal system. And you also need to know recommendations for further changes that seek to address those problems, that seek to improve the effectiveness of the legal system. When we're talking about recent changes, it's generally about the last 3 to 5 years are acceptable, and I really would recommend that you have a recent change in civil procedure, a recent change in criminal procedure that addresses the problem, and also that you have a recommendation for change in civil procedure and in criminal procedure that addresses the particular problem that you choose. Okay, so we're going to look at 2 problems that affect people's ability to access the legal system. 2 ones are financial inequities affecting access to the law, and also we look at delays affecting people's ability to achieve a timely resolution. So the first problem we look at is financial inequities that affect access to the law. So we've seen a lot over the course that people with limited financial means really struggle to afford to have their case heard in court. That if they do go to court, sometimes they can't afford the best legal representation, and therefore they're less likely to achieve a fair and unbiased hearing. Generally that's caused by 2 things, the high court fees involved in accessing the legal system and the need to pay for costly legal representation. So that's the key problem. And what we look at, one recent change in civil procedure, and we've seen this a lot, is the increased use of ADR and tribunals. So things like mediation, conciliation and arbitration sessions have proved successful in resolving, in particular, small civil disputes. And all Victorian courts now and VCAT have embraced the practice of referring matters to mediation, conciliation or arbitration. Just one point in this, because it's a recent change, you must really say increased use of ADR and tribunals. ADR and tribunals have been around for a long while now. They're not really a recent change. What the change is the increased use of them, the increased use of them within the court system and VCAT, really just embedding them within the system. So there's not alternative dispute resolution, but really just part of the process of having a matter resolved through the legal system. Another recent change in civil procedure is to use judge-led mediation. There was a 2-year pilot set up in the County Court and the Supreme Court in 2010 that uses mediation to try to resolve disputes. So they're working with superior courts, the County Court and the Supreme Court. They have a judge, support staff and an ADR coordinator with the purpose of placing ADR firmly within the court system. Some suggested changes for civil procedure, so something that hasn't happened but something that could seek to address financial inequities affecting access to the law, include abolishing juries, which we saw as an alternative to the jury system previously. That would reduce the cost involved in taking a matter to court because you wouldn't have to pay for a jury and the case would likely take less time, which would reduce costs further. You could also seek to increase the jurisdiction of tribunals, so they'd be able to resolve disputes quickly and cheaply and increasing access. So basically we'd have more cases heard through tribunals. Potentially at the moment we have just cases up to $10,000 in the magistrates court being referred to arbitration. You could increase that to $50,000 and refer more cases to tribunals to be resolved there. One recent change in criminal procedure was to simplify the criminal procedures. In 2009 the Victorian Parliament passed the Criminal Procedure Act, which consolidated a number of acts into just the one piece of legislation, and it ordered sequentially according to the criminal pretrial and trial procedures. That made it easier for people to find the law, perhaps reducing the cost in their ability to have to use legal representation and increasing their ability to access the court system. Another recent change in criminal procedure is to introduce sentence indication to try to encourage early guilty pleas, which reduces the time and cost of a trial. This is where the judge advises the accused whether they're likely to be sentenced to imprisonment should they plead guilty to the offence at the first available opportunity. So the judge might indicate that if they plead guilty to an offence, they'd be sentenced to potentially community service rather than imprisonment, and therefore encourage people to plead guilty early and avoid the cost and time of a trial. Some suggested changes for criminal procedure to address financial inequities include starting a public defender scheme. It would be essentially the defence equivalent of the public prosecution. The public defenders would be paid by the state, but independent of the government, so they'd be available to represent clients who are charged with serious criminal offences and had been found eligible for legal aid. Another suggested change in criminal procedure is the greater use of legal insurance to defend criminal cases. So this would be where people are able to take out insurance policies. They'd pay a monthly premium, and therefore if they were ever charged with a crime and needed legal representation, then their insurance company would cover the costs involved. It'd be similar to medical insurance, where you pay a fee regularly, and if you're ever injured and go to hospital, then your expenses are covered there. A second problem is delays affecting access to the law. We've seen a lot of causes of delays over the course. Generally, it's due to lack of court personnel, lack of courtrooms, lack of resources in the legal system relative to the number of cases that have to be heard. In civil cases, increased litigation and improved technology resulting in more information that needs to be examined at trial have led to increased delays. And in criminal cases, things like the difficulties in collecting evidence, or the fact that forensics science is able to collect more evidence that needs to be examined in court, or the fact that committal hearings tend to delay the process. The effects these delays have is that they increase the stress of people not knowing the outcome to a case. They increase the hardship if you have to wait for a financial settlement in a civil case. They reduce the reliability of witnesses. The longer the case drags on, the less able they are to remember the events. It also can increase the time that people have to spend in remand in criminal matters, and if the person was innocent, that means that they've been locked up unnecessarily. A recent change in civil that tries to address this again is the increased use of alternative dispute resolution. So programs such as the diversion to mediation programs, court-led mediation in the magistrates' court, judicial resolution conferences, and judge-led mediation in the higher courts all assist in reducing the settlement time for the parties, as they don't have to wait for their case to be listed in court. Further, having cases resolved outside of court frees up the court time and resources to hear other cases, contested cases, quickly as well. Another recent change in civil cases is the establishment of the commercial court. This is a new division of the Supreme Court established in 2009, which combined the existing commercial list and the corporations list of the Supreme Court into the one division. Its aim is to resolve the disputes in a more timely and efficient manner by taking a case management approach. Again, it has a lot of expertise in hearing those type of cases over and over again, so it's able to hear them quickly. A suggested change for civil procedure is to extend the court hours that the courts are open for. That will promote flexibility. It increases access to the courts because there's more time for cases to be heard. It also means that people wouldn't have to take time off work necessarily, so it eases the stress on them. However, that would increase costs because you'd have to pay court personnel like judges to be there for longer hours, so that costs money. Another suggested change in civil is to increasingly encourage people to attend early mediation, early on in a civil case, to try to resolve the matter before costs are incurred in various pretrial procedures. In particular, before they get into the discovery stage, where they're going through the interrogatory process, where they're just going through discovery of documents. Those things can cost a lot of money, and early mediation tries to head them off. A recent change in criminal procedure is to introduce time limits for criminal procedure. In 2009, they set time limits for various stages of the criminal pretrial procedure to try to ensure that the cases don't drag on unnecessarily. Another recent change in criminal we've already seen is simplifying criminal procedure. In 2009, criminal procedure was simplified to try to reduce delay. Another recent change in criminal procedure is the sentence indication again, to try to encourage an early guilty plea by giving people an indication of the sentence they'd be likely to receive, to try to free up the court time by saving that time at trial. Suggested change in criminal again would be extending the court hours. That promotes flexibility again, increases access. People wouldn't have to take time off work. Again, that would increase the costs involved. Another suggested change in criminal procedures would be to abolish committal hearings. Because the majority of cases proceed straight through to trial, some people have called for committal hearings to be abolished, and that people should just be presented directly for trial. That would potentially reduce the time needed for people to prepare for and to attend a committal hearing. Okay, so just to recap, we sort of covered a lot of information there, but really you just need to know two problems. So financial inequities affecting people's access to the legal system, and delays affecting people's ability to achieve timely resolution. You also need to know recent changes that seek to address financial inequities. You need to know suggested changes that address financial inequities, and you also need to know recent changes that seek to address delays in the legal system and suggested changes that address delays within the legal system. So really, just need to pick the ones that make sense to you, and that's it.